Okay. 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 Next session. Yes, the next session. And the next session, which we'll be dealing with, sorry, sir, is on substantive criminal law, the updates. And that is the meat and drink of today's session. And the topic in question, as I am looking at the program now, of session is already seated, who is no other person than Honorable Justice Abdul Aboki, JSC retired. Let us give him a round of applause. The lead presenter is no other person than the coordinator of the Rule of Law Development Foundation, Mr. JB DAUDU, Senior Advocate of Nigeria. Let's give him a round of applause. And the co-presenter is Chief Kanu Agabi, Senior Advocate of Nigeria, who have all been here seated. So at this point in time, we'll move straight into the lead presentation and the co-presentation, and then we adjourn for break, and then we take the discussions after the break. So we are going to commence with the chairman's opening remarks, and then we move to the two presentations. There are two presenters. The lead presenter is JB Daudu SAN, and we'll be talking about substantive criminal law. Various aspects. What has happened in the last 2 years? Last year, we did not have a conference. So, at least within the period of 2 years, what are the latest developments in substantive criminal law? Not only procedure. And there's also the issue of harmonization, the harmonization debate. Is it time that we had a uniform code of criminal law across the country, as opposed to what we currently have, where each state has its own criminal code or law? These are very important issues and front burner issues. Permit me at this stage to yield the mic for this session to commence. As we stated, we have discussants. The discussants will be introduced. Yes. So at this point in time, please let us give a resounding round of applause to the chairman of session, please.
The coordinator of this annual Criminal Law Review Conference, our legal colossus, Chief Kanu Agabi, other senior advocates here present, and participants. I will say good afternoon to everybody here. Mr. Kanu Agabi has a function to attend this afternoon, and we accord him the privilege to hear his contribution to this topic. And when we come back, then we can open the debate properly. Mr. Kanu Agabi, you are here invited.
Thank you.
My Lord Justice Aboki, my brother JB, the coordinator of this conference, I whispered to JB again that I will take another 100 copies of the second book which has been presented. The reason is this. Number one, I have many people visiting me, and I am always at a loss what to give them. JB, you have given me something to give. Thank you very much. Secondly, I have no doubt that the question will arise someday when I stand before the Lord as to what books I wrote. Because I have never written a book. So I am going to say to the Lord, forgive me, I didn't write any book, but I bought books. Here they are. So, JB, you have given me a passport to heaven. I have pleaded to be allowed to speak first because my presentation is merely going to be introductory to what JABI is going to say. I will speak for a few minutes because I have another meeting to attend. And people are coming from far and wide. I have to be there. JABI, thank you very much for permitting me to make these introductory remarks to the presentation that you are going to make. I am grateful to the Rule of Law Development Foundation for the privilege of participating in this conference. I am even more grateful for the opportunity of addressing this subject relating to the multiplicity of our criminal laws and the debates over their harmonization. Let me start by saying that there is no shortage of knowledge concerning these matters. We never stop thinking about them. We never stop talking about them. We have written so much on this subject. For a nation whose people are as intelligent as we are, you may be certain that there is a large body of knowledge about these matters. Even though we have for many years now been stigmatized as a corrupt nation, the reason we continue to survive as such is because we are a hardworking, intelligent, patient, and resilient people. Nevertheless, while we are definitely not short of ideas, we have fallen short in the area of action. It is not enough to have good ideas. Good ideas are of no use if not put into action. It is not enough to have good laws. We must also have good men and women to implement them. If we do not implement the laws, the tendency will always be to blame the laws for our inadequacies. And that is why it is said that the more laws, the more crime. With the advent of civil rule in 1999, at a time when corruption had permeated every department of our national life, we went from one extreme of dictatorship to the other extreme of liberalism. When you are under a dictatorship, you are not under law. You are under the rule of the dictator. And dictatorship never takes root until corruption has taken root and permeated every part and every individual. At that time, there were laws, just as there are even now, but they were never enforced. The will of the dictator prevailed. With the adoption of the presidential system of government and the vesting of all power in one man, the president, you can say that we are still under a dictatorship. The only difference is that this time it is a dictatorship under the Constitution. The essence of this dictatorship under the Constitution is that all executive power so vested should be exercised to bind a nation with divisive tendencies. I do not know if the nation is more united today under the presidential system of government than it was in the past. This vesting of all executive power in one man extends to the states, where all executive power is vested in the governors. In some of the states, it is said that the structures for accountability have been destroyed, with the result that the governors of those states are not accountable. In such states, there are said to be only two arms of government, the executive and the judiciary. The legislatures in those states are said to have been assimilated by the executive. As for local governments, they do not exist as a tier of government. Why do I make these remarks? Because these are the factors responsible for the upsurge of crime and the consequent proliferation of the laws. And so it seems to me that an appropriate starting point in our discussion of the multiplicity of criminal laws is an examination of the reasons for unrelenting upsurge in crime. Our ancestors did not have a police force such as we now have. They did not have an army such as we now have. They had to govern their lives. The forbidden fruit was edible, but it was forbidden. They were told not to eat it. They proceeded to eat it. The Lord then imposed 10 commandments in place of the one. We are proceeding in exactly the same way. In the past, we had very few criminal laws. As these laws were disobeyed, we multiplied them. The same with the rules that govern our criminal procedure. They have become more numerous and more complicated with time. We make more laws, and when those laws fail to solve the problem, we make even more laws. The question arises because of the notion now gaining ground that we have too many laws and institutions for the prosecution and punishment of crime. But is that really so? In a nation of over 220 million people, do we have enough policemen and women? I do not think so. As at 1999, the nation had a police force of about 130,000 men and women. In 8 years, the government was able to double that number. But what about training them? What about educating them? What about paying them the appropriate wages? What about providing them accommodation? What about equipping them? We expose our policemen and women to many situations over which they can do nothing. They work under the most inhuman conditions, resisting crime with their bare hands. In the end, their minds are brutalized, and we proceed to condemn them when they disappoint our expectations. The same with our judges. We have too few courts and too few judges. The judiciary is founded on the premise that the work of the courts will be limited. If that work becomes unlimited, the judges, however honest or hardworking they are, cannot cope. After a while, they become indifferent, and then we condemn them. I will say nothing of the great temptations that we heap on the judiciary and expect them to resist, when for over 20 years, judges and justices have been on the same salary. As earlier stated, the crime rate in the nation has increased. Major crimes such as kidnapping, murder, burglary, fraud, terrorism, and so forth are on the increase. But I want to stop at this point because, as I said, my remarks are merely going to be introductory to the presentation that my brother JABI DAUDU is going to make. But I want to make this appeal to the nation, and I make it to those in authority. If we go on committing crimes, and government is the source of crime, it's true. The crimes that institutions like the EFCC, the ICPC are called upon to contend with are coming from the government. It is not enough to make more laws. We must correct ourselves. Right now, we're dealing with elections. We must restrain ourselves. We must ensure some discipline in our conduct. Otherwise, no matter how many the laws are, if we don't have good people to enforce them, the laws are not self-enforcing. They need good people to enforce them. So why don't we have good people? We do have good people, as I said before. We're a nation of good people. But unfortunately, the people in leadership, the people holding offices, are not our best because we are running a government of patronage. From 1968, from 1967, when we multiplied institutions, multiplied the states, we met the needs that arose by appointing unqualified people into high offices. And that's what's going on right now. The boundaries of the states are rigid. And so, a man, no matter how qualified, cannot find employment in states other than their own. These are the real problems that we have. The institutions for law enforcement are inefficient. And so you find that those institutions that are perceived as efficient become congested, like the EFCC. People are taken to EFCC cases which are not the type of cases for which they were founded. But let me leave it at that. JABI, you have written the books. I will collect some and go and distribute as my contribution to this debate. May the Lord bless you.
Then Dr. Hassan Liman, Senior Advocate of Nigeria, is also on this panel. Audu Anuga, SAN, is on this panel. And then we have, I saw Bankole Akomolafe, Senior Advocate of Nigeria, is here. These are those who will be discussing this paper. And immediately after, this is the only session for today. And I'm sure we'll be able to manage our targeted time of 4 o'clock. We also want this session to be very interactive. So I urge our participants to please take note of some of the major points that are going to be raised both through the lead presentation and the discussions, so that we'll give an opportunity for the audience to also share their thoughts. So at this point in time, I want to also inform us that the chairman of this session is still very much with us. Let us give Honorable Justice Abdul Aboki, JSC retired, a resounding round of applause, please. He is here. And at this point in time, I'm sure he will give the closing remarks at the end of the session. At this point, permit me to, with leave of the chairman, invite the lead presenter, JB Daudu, Senior Advocate of Nigeria, coordinator of the Rule of Law Development Foundation, to give us his presentation on this topic. Thank you very much. Let's give him a round of applause.
Well, the Honorable Chairman, with your leave and all protocols duly observed, I will start the presentation of this paper. It's on updates, judicial updates, and legislative developments in the area of substantive criminal law, covering the period 2022 to 2023. The annual Rule of Law Development Foundation conference is usually a forum to articulate developments in areas tangential to criminal justice, such as the law of crimes, and we divide it into two: the substantive criminal law and criminal procedure, the law of evidence, substantive and electronic, and the examination of developments in the prosecution of white-collar crimes, the administration of correctional centers and remand homes, sentencing guidelines, and the retrieval or recovery of the proceeds of crime confiscation and of freezing of assets linked to financial crimes, the laws associated with the protection of vulnerable persons such as women and children to the society, and many other emerging areas of the criminal justice system. In the past 4 editions of this conference, I have always undertaken to report and espouse on the yearly developments in this strategic area of our criminal justice system. My approach has always been to highlight the judicial decisions emanating from the superior appellate courts, that is the Supreme Court and the Court of Appeal, on the core subject matter of criminal law, and to comment on the developments or otherwise showcased in those decisions before concluding whether or not they advance the cause of justice. The Supreme Court is at the heart of our justice system, and since the law is substantially what the judges say it is important that we hinge the judicial part of this discourse on a critical examination of the pronouncements of not only the Apex Court, but also on the prominent decisions of the Court of Appeal, the Federal High Court, and High Courts of States, and the High Court of the Federal Capital Territory. I will also examine the legislative updates emanating from the National Assembly, and if any, well, let me just confess, there was no point in covering those of the states' houses of assembly, just because of the doctrine of covering the field, which the National Assembly exercises. And at the end of the exercise, we'll interrogate the issue of whether these updates have in any way positively contributed to the peace, order, development, and good governance of our country, Nigeria, within the period under review. Now, I've approached it in a rather unorthodox manner. And in looking at the subheading of the crime-free society, these are the issues that I brought out. The aspiration and target of every society is to be rid of its criminal elements and their deleterious effects. What is the bane of the Nigerian society? What are the acts of criminality that cause misery, pain, and the destruction of societal values? They can easily be identified, and they include, but are not limited to, fraud, corruption in public and private spheres of life in Nigeria, kidnapping, banditry, terrorism, cyber crimes, crimes arising from cultism, crimes arising from electoral misconduct, etc. These modern newfangled crimes that have pervaded our society are the product of eroded values, bad leadership, and since I listened to Professor Anya, the followership are also to be blamed very heavily, and insensitive followership. Everybody is waiting for their turn so that they can pounce on the national cake. The prime duty of the Apex Court as the highest court of justice, and to a very limited extent of recent, Apex Court has been described as a policy court, but I say that it's only to a limited extent. It's to ensure that the highest standard of criminal justice is strictly maintained across the length and breadth of Nigeria. How can the Supreme Court discharge this role? The point can be illustrated thus. Now, I may just give a background explanation to this, what I'm about to do. If it is agreed to a point that the Supreme Court can shape policy, legislation, and the societal balance through its judgment, then to that extent, its judgments must mirror those progressive ideals that flow from the cases that come to it. So I'm now looking at the issue of prosecutorial investigation. As I said, the propensity of investigators, be they operatives of the Nigerian police or other services such as the NDLEA, Customs, Civil Defense, EFCC, is to prefer recourse to confessional statements or confessions as their preferred mode of establishing the ingredients of the offense or offenses upon which the suspect, that is defendant, is charged to court. I identified the problem in this manner. There's a book we wrote, which I co-edited with Professor Adekunle, the former DG of the Nigerian Institute of Advanced Legal Studies. And in the chapter assigned to me, I described how our investigation machinery for criminal cases was at that time. I said, because accused persons have constitutional rights and are protected by bills of liberty and fundamental rights, investigative agencies cannot, in gathering evidence with which such an accused person will be prosecuted, engage in illegal and unconstitutional acts, such as eliciting confessions by threat, force, torture, inducement, or promise of temporal advantage that is inadmissible in law and, if wrongly admitted, will be expunged on appeal. After a consideration of the efficacy of forensic investigation just before independence, and immediately after, where it was identified that the penchant to resolutely investigate crimes through forensic means had waned, the deleterious effect of such neglect, that is, to continue with forensic investigation as the basis of arraigning suspects to court, was identified below as this. I said the product of every investigation is a report. And what good is such a report if it is based on only a suspect's account of events or from his confessional statement elicited from him through strong arm tactics and other uncomplimentary procedures? The test of such an investigatory process is whether it will bring the culprit to justice. Additionally, the courts will ask if it is possible to presume that the investigator speaks the truth through his report. The latter can only be ascertained where all the investigatory procedures and processes have been subjected to due process and the rule of law tests. Can this presumption be upheld in Nigeria? In the face of massively established acts of impunity consisting of arbitrariness, torture, and extrajudicial killings of suspects and other unspeakable acts. This is quite doubtful if one considers the availability of damning, unchallenged, and uncontradicted evidence documented against the police. It is not necessary here to go into the qualities of thoroughbred or even good police investigators. It is assumed that those involved know that thoroughness and dedication are the key words. However, the present state of affairs is propelled by the exact opposite, of which are floppiness and insincerity. Without investigation, cases cannot be won. Indeed, it does appear that the police want to take their cases to court when it is easy for them to eliminate hardened criminals on their own terms against all norms of domestic and international practice. This is what was said about 10 years ago about the state of our investigation. Now, this is the situation. Between 2022 and 2033, the Supreme Court affirmed the conviction of appellants in the following cases based on respective confessional statements, and have identified 19 cases wherein all the Supreme Court looked at is it is possible, it is acceptable, it is lawful to convict an accused person based on his confessional statement. And they proceeded to affirm it. The simple point being made here from the trend of the Supreme Court, as shown by the above cases, is that the policy of affirming conviction for serious offenses, such as murder, culpable, that is culpable homicide punishable with death in the North, manslaughter not punishable with death also in the North, armed robbery, kidnapping, terrorism, all these offenses that carry the death penalty. Through excessive recourse to confessional statements, which in most cases are thought to have been forcefully or extraordinarily obtained from the defendant during pre-trial investigation. The view out there is that if the Supreme Court is a policy court, and it is to a very large extent a policy court as it should be, it should promote the policy of forensic investigation, which has been defined, and the source of the definition is there. It has been defined as the use of scientific methods and techniques to analyze physical evidence for criminal and civil legal proceedings. And it serves as the foundation for establishing facts, reconstructing events, and identifying persons involved. It is necessary to state here that forensic scientists and crime scene investigators work diligently to uncover scientific evidence that can be used in legal proceedings. And they use practices such as DNA analysis. Here that Lagos is trying, in this Mobad case, they've gone into coroner's inquiry since, and they have not been able to come out with a result up to now, despite exhuming the corpse. Fingerprinting, bloodstain pattern analysis, ballistics analysis, toxicology analysis, digital forensics. Now, before I go further, let's be realistic to ourselves. How is it possible for our police force to adopt this mandate or this model of investigating cases? Which is the reason why, because there's no template from crime scene investigation. Do you shut down the crime scene after an event has happened? Do you go about picking blood samples, stains, footprints, and everything? Most of these offenses can be resolved within 3 days, especially given the carelessness of the Nigerian criminal, because they have not acquired the sophistication of their counterparts abroad. So when you know as a police investigator, in fact, the first question you are asked is, abeg, who you suspect say do this thing? Who is the suspect? So you call your enemy or somebody who was not even around. Then they pounce on him, beat him black and blue when everybody has left the station about 3 a.m. in the morning. And when the man has seen that, well, let me not die here, he simply writes, he says, bring, let me sign. He signs. Now, it now has become a pattern, a habit. They just sit in the station, and when people, crime diary, to even go to the scene, you hear excuses like, we have no vehicle, no fuel inside vehicle. Bring money, let us go and get vehicle to go. Each time you come, no paper to write. Biro, bring money for biro. And so the desire to get the job done, the attitudinal desire is not there. And as I build it up, you would see how dangerous and critical a situation we're in. Now, our courts, and this goes for the National Assembly too, should they desire for Nigeria to ascend the ladder of advanced and progressive nations, must encourage the policy of the use by our police and even the AFCC. They lose all their cases, I'm sorry to say, because there's no forensic financial accounting. How many people are chartered accountants who are trained in forensic accounting, who are trained in tracing of assets that are employed there? No, they will not employ those ones. They'll actually employ the people who really have, and I take this view that it's not a matter of quota system. It is a matter of the fact that people bring the wrong people, like Chief Kano Agabi said, to come and fill the posts. There is no state in this country that has not produced a first-class candidate. There is no state in this country that does not have sufficient graduates. There is no state in this country that does not have brilliant people. Why is it difficult for us to pick the correct people, train them, and put in the right place? But the problem we have is everybody goes to bring who he wants to bring and puts in positions that the person you are putting there does not have an affinity or a desire to do the work. All he wants is that Uncle has said I should just go and sit down there. And the day they bring money, they share with him, he's happy. But will we make any progress by doing that? So the courts and the National Assembly, and because this is what we should say, it's not a matter that we don't have the laws, but it's a situation of where we have gone off tangent. It is time that Nigeria keyed into the rapid advancements in technology that open up new avenues for evidence collection and analysis. That I have said referred to introduction of DNA, fingerprinting, and the people have even gone so far ahead. There is artificial intelligence, which can be quickly used to solve problems, machine learning, and blockchain. I used to think that blockchain was something that Yahoo boys used for as part of their business. But it's a very serious business for intellectual progress in business. Now, there are also other types of forensic investigation, like we said, crime scene analysis, digital forensics, forensic accounting, forensic toxicology. Now, if you call the name of this thing they'll first tell you they're not interested. They tell you, no, this can carry this book, this is our book people, no, don't come with that. They should go away. Each time of investigation focuses on varying kinds of evidence and employs specialized crime scene investigators to carry out the task. And because different people have different work that they do, one problem we have in Nigeria is that we can never agree to work together. One investigator will say, what is this man looking for here? Is this his case? Is his brief? This is my brief mentality. And it's not being done, for the sake of the work. Because if the original target is what can I get out of it, then of course you will be shielding the pathologist from, or you go and collect the report when you should go and collect it. So many things will be done that a case that should be determined hot, the trail goes cold and they park it somewhere. So we will even be talking about two advanced things when we say that they should pursue biological evidence, blood splatter, even hairs, digital evidence from computer, mobile devices, and other electronic sources. If they collect your phone when they're investigating, is to see how much you sent to X or how much you sent to Y. You give them money, how much? Then they'll check you check your phone. So these things are things that we must change our mentality. We need leadership in those areas to be able to. At one point, I was even thinking that, well, will it not be? We are training graduates every day. They are still young. Their minds are adaptable. Can't sack the entire force on the ground and then begin to train people, on human rights, on forensic investigation, on the idea of saying that, look, these ancient people will soon go and leave you and this country. And if you don't have the right tools, and that's why when they go and attend the conference of crack police investigators, maybe in Scotland Yard, they are talking above the Nigerian delegation's head. Because those ones are waiting for lunch break, they go and eat, go and shop on Thursday before they board the flight on Saturday. So we will never get anywhere with this thing. So in the collected evidence, normally should be sent to a crime lab for processing. How many crime labs do we have? NDLEA, that is supposed to be the crime lab. You know how the place is now. The only thing probably they can analyze for you is whether a drug is cocaine or whether the Panadol has 30% of Panadol in it. But pure toxicology, they are not interested. They are not in that business. So we are in trouble. There is no doubt that criminals of all genera are massively taking advantage of the ever-increasing sophistication of crimes. Consequently, our courts and the legislature must see the imperative for advanced forensic tools and techniques. As we move into the future, the field of forensic science will continue to evolve. The white man is not sleeping, or the Western world is not sleeping. They are evolving new things every day to make it difficult and to make their society difficult for criminals to thrive and to make their society very comfortable to live in. Where does all this take us to, and what is the nexus of this discourse on the need for forensic investigation as a global template for investigating crimes in Nigeria? The answer is that we are at a point of our societal development, particularly in our criminal justice system, where our template for resolution of crimes and punishment of criminals is or should be based on forensic investigation, as described above. Our Supreme Court, and people may just say, saddling this very noble gentlemen with work that ordinarily should not be their own. We should set the mark in their judgments for our law enforcement agencies to follow. Now you see my suggestion here. Now, validating the recourse to exclusive proof by a confessional statement in very serious criminal cases, as demonstrated in the 19 cases listed above, all within the span of 1 year by the Supreme Court, I say with the greatest respect, is not the best template to adopt for the resolution of crimes in our justice system in the 21st century. The templates set out above, which have been domesticated in all serious jurisdictions, Western and non-Western. And I say non-Western because go and commit an offense in Dubai. They are not going to have resort to istihara to find out who is the criminal. They will employ the same forensic investigation that their colleagues are employing in New York, in London, and to a large limited extent, some of the Scandinavian countries. So why are we, when our Arab brothers can be far ahead, where are we just jumping on the same spot? So the truth is that we are no longer a fledgling nation. Every time they say Nigeria is, we are emerging young, then we are young democracy, we are fledgling this. We have had contact with English law, practice, my Delta brothers will confirm that, and procedures since 1864. when Lagos was annexed as a colony of the British Empire. And it's almost 200 years now into the bargain. And our criminal investigation processes and templates have not advanced beyond those that I met my uncle, who was an inspector in the CID. In those days, he retired as a deputy commissioner of police. And even the CID of the 60s and 70s, when headed by Alhaji Mohammed Gamboji Maita, would give us better results. After all, were they not the ones? Within 3 days, they apprehended ST Reding and those people who perpetrated the Jeba sugar robbery there. In those days, the country worked. They followed forensic techniques, brought them before the court. The appeals failed up to the Supreme Court and the Supreme Court did not, of course, they would not confess they were hard men. So they had to bring proof, and it was forensic. So what we're saying is that we've done it before, we can do it again. So the Nigerian police, EFCC and ICPC, to mention a few, based on the state of the law, validated in 19 cases, have now been or appear to be emboldened to prefer the extraction of confession from suspects. And who will not do that? If you know that you can take confessional statement to court, and from the magistrate to the high court, the judge is most likely to say, well, if it fails trial within trial, that appears to be the end of the matter. The common law system from which we borrowed or received the jurisprudence of confession-based convictions they've all moved to forensic-based conviction. And even on the rare occasions that they had recourse to the use of confession as the basis of conviction, their courts have all tangentially applied the rule in the English decision of R against Sykes, which was followed in Kanu against R, that's Kanu against Rex. And also, I've just cited the Locus Classicus, Corporal Jonah Dawa against the state, where the 6 tests for the verification of confessional statements before any evidential weight can be attached to them was set out. Now, put the tests here. 1, is there anything outside the confession to show that it is true? 2, is it corroborated? 3, are the relevant statements made in it of facts, true as they can be tested? Was the accused person one who had the opportunity of committing the offense, the crime? 5, most importantly, is his confession possible? 6, is the confession consistent with other evidence in the case? I'm asking you for corroboration. Now, I submit that these tests, with the greatest respect, when applied to every case where a confessional statement is the basis upon which conviction is required, must be understood to require something much more than the bland confession itself. That means the law did not just put those 6 tests for you to rely only on the confession. It is requiring something outside the confessional statement itself. And these 6 tests are an invitation for you to jettison the bare confessional statement as it is, and only confirm the contents after additional evidence justifies or confirms the contents of the statement. Which, and I submit that in this age and time, that thing outside that the 6 tests are saying you should go and look for to confirm its contents is the same as forensic evidence. So, in my humble view, the courts directed or led by the Supreme Court ought to be in the vanguard of insisting on the highest standards of proof and certainty, where the only evidence against a defendant is a confessional statement. Not only that, the court should also insist that both prosecution and defense counsel on their own, and within the ambit of their case file, demonstrate how they have applied these tests to their respective cases. If as a prosecutor they ask you, is there anything outside this confession to show that the confession is true? And that is part of the requirements you must show to a court. And if you don't have it, that sows the seed of doubt in the mind of the court. Then you will be tempted to work very hard to investigate beyond the mere ipsi dixit in the confessional statement. So that will be that on this part of the foundation of every criminal case, which is investigation. I now go and deal with another issue which I should not be accused of being an interested party, but I just thought it was a matter of serious public interest. Remand of an accused person in place other than correctional service. The Supreme Court, by His Lordship, Honorable Justice Okoro of the Supreme Court, in Oguche against FRN, citation provided, where before the trial court, the discretionary power of the trial judge to remand the appellant in custody of the DSS instead of regular prison custody was challenged by the appellant. The issue of the appropriate place where the appellant / defendant should be remanded, as between the two places mentioned above, came up for determination. In upholding the decision of the trial court, the Court of Appeal observed that the general prison is a more neutral custodial facility than the custody of the DSS. However, the lower court said that, well, the order to remand him in the custody of the prosecution is by its nature not a punitive one, but preventive. It appears that it is meant to prevent the accused persons from being tried, or meant to prevent the accused persons who have been tried for terrorism from escaping and then making life difficult for other people. Now, His Lordship, Justice Okoro, affirmed that situation. But what I point out is that, or take out of it, is that the power to remand, whether in prison or whether in the place suggested by the prosecution, urged by the investigator, is entirely within the discretion of the court. It's a discretionary matter. Thus, it is clear yes, as I said, it's in we're proceeding to page 9. However, I have now referred to the case of FRN against Godwin Emefiele, that there was a flagrant disobedience of the order of the Federal High Court, Lagos, per the Honorable Justice Owibu, who had on the 25th of July 2023, in addition to granting the appellant Emefiele bail on stringent terms, ordered him to be remanded at the Ikoyi Correctional Center instead of the custody of the DSS, who had held on to him for reasons stated by them in their counter affidavit. And this is the reason they gave: for administrative convenience and to reduce huge costs of investigation, especially frequently commuting of the investigation team from the DSS headquarters in Abuja to Ikoyi Prisons, Lagos, in head of court. That's the reason why they said they were not going to obey the order of Owibu. Thus, undeniably, the FRN, in my view, had grossly disobeyed the order of the court, directing that the defendant be remanded in the custody of the correctional center, pending, and for information is no longer the suit. This charge has been withdrawn so we can comment freely on it. Remanded in the custody of the correctional center, pending the perfection of his bail conditions or his trial, whichever is earlier. The conduct of the government agency holding on to the then CBN governor, Godwin Emefiele amounted, in my humble view, in very clear and unmistakable terms, to a violation or breach of the positive order of the Federal High Court. This aberration has far-reaching consequences on the quest for Nigeria to be a rule of law compliant state, whose institutions ought to manifest strength and compliance with the tenets of the rule of law and separation of powers. For the avoidance of doubt, it is necessary to reiterate the core principles of the rule of law. And the definition is there, I think we all know it. And have all went ahead to set out the constraints on government powers, which includes absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil judgment, justice, and criminal justice. If you go through it, you see how they are linked to the efficiency of any institution. The observance of these things are linked directly, tangential to it. Applying these principles and factors to the well-described malfeasance or misconduct of the DSS described above, can its conduct to be described by any stretch of imagination as rule of law compliant? The answer is obviously in the negative. Court orders are meant to be obeyed and due process followed. Nigeria cannot make any progress if orders are complied with in the breach instead of its observance. I just felt to put it on record that we still have a long way to go when this kind of matters come up. Then on the diminishing constitutional rights of accused persons, defendants, the current attitude of Nigerian courts. I started by just quoting the famous dictum of Viscount Sankey in Wilmington against DPP, saying, and I'm sure all those who did criminal law in either 200 level or 300 level will remember that famous saying that throughout the web of English criminal law, one golden thread can always be seen, and that is the duty of the prosecution to prove the prisoner's guilt and then subject to exceptions. Now, this golden rule in Wilmington has been encapsulated in our Constitution into the presumption of innocence and in the Evidence Act, placing the burden of proof on the prosecution. And over the years, we grew up with William Blackstone's statement, and someone says Benjamin Franklin, that it's better for 10 or even 100 guilty persons to go scot-free than for one innocent man to be convicted. Now we have shown in this discourse that the attitude of our apex court to confession induce convictions. And another area where zero tolerance is exhibited is where there are concurrent findings and concurrent conclusions. In most appeals, for those who go to argue criminal appeals in the Supreme Court, once there are concurrent findings, and you know they're very busy, first question they will ask you is, how do you intend to surmount these concurrent findings and conclusions? But then when you contrast it to these better for 10 or even 100 guilty persons to go scot-free, then we begin to plead for more patience. But then they, again, balance it with limited time. So there is an issue here, and I recorded from page 11 to 13, 35 criminal appeals, all of which I read, which were dismissed on the basis of the fact that after examining the record and the concurrent findings of fact, they didn't expect the appellant to have anything useful to urge. perhaps he should try a prerogative of mercy. But it must be stated that most of the cases listed above already include those ones in which confessional statements were relied upon. It does appear that rights of accused persons, which we took for granted 30 to 40 years ago, are now few and far between. For instance, over the years, there was a hard-fought battle in both the northern jurisdiction and the southern jurisdiction, and I will explain shortly. To get accused persons to be given the contents of the case file, and I'm sure the chairman will recall the CPC, that there was a provision, I don't know if it's section 134, which says that the contents of a case diary will not be given to the accused person. So we tried as much as, being a young practitioner then, to try and overcome it. Two decisions were helpful. Liono against the state, provided the citation, and Gaji against the state is a 1975 decision, which opened the way a bit. And to an extent that you needed the statements to contradict the witness or someone, the prosecution could be compelled to give that to you. But the question asked, I think in Gaji, my lord, is that how do you know there is a contradiction when you have not been given the statement? So we kept running around in circles. So I listed the decisions, but over the years, from 1979, when we had the equivalent of section 36, subsection, I think 66B, sorry, which guaranteed the right of an accused person to adequate time and facilities. And we let us praise the courts when it is time to praise them. They expanded the scope of that constitutional provision as overriding those provisions of the CPA and the CPC, which had banned the provision of statements to the accused person's counsel. So for some time, the practice of giving the contents of the case diary, especially the reports, the medical reports, pathologist report, gained sway through the inroad. But as with everything, because there is no forensic examination, more cases were now being lost on account of the fact that, and it seemed that you see the cases in the footnotes there. From Weke and Shema, the Supreme Court placed some kind of conditions precedent on this adequate time and facilities. And in Weke, it was held that it was not a right that is automatic or self-executory, meaning that you must apply for it. In Shema, His Lordship Baggy, now the Emir, JSC, held that unless plea is taken, you cannot be given those papers, those statements, when you have not been arraigned. So what we were given with the right hand, I think we collected back with the left hand. But it's a continuous discussion. There is no quarrel. It's a matter of us going to try and persuade them some other day. But we need to escalate it to at these levels, so that when it, because it's not only going to be me involved, it will affect other counsel. They will say, this has been discussed at a forum, and we think that if we are to enjoy this right, we should enjoy it in its fullest proportions. So concluding on judicial updates, and I had said that we don't need to go into what is the defense, which are the new cases on the defense of self-defense or private defense, provocation. We've been doing that over the years. Every lawyer, you wake anybody up, he'll tell you what provocation is. He'll tell you what the ingredients of murder or manslaughter is. Page appendix from page 31 to 37 which tells you cases of armed robbery, they've cited even trust criminal procedure. So you find that there's an easy guide should you be faced with any case of that nature. So that, with respect, will be all for judicial updates. Now, legislative updates. I will just run through it briefly. To consider at this stage the involvement of the National Assembly in the creation of new crimes in our statute books, which facilitate the advancement of our criminal justice system and promotes the well-being and safety of our society. A discussion of the topic, judicial updates and legislative developments, is incomplete without an overview of all legislations enacted by the National Assembly within this period. That is the period when the last conference took place in 2021 and today. It is pertinent to note that it's difficult. It's not exercise is usually hindered by the inability to gather, at the click of a mouse all the recently enacted legislations from the National Assembly. However, they have a bill tracker, but the bill tracker does not tell you when it was turned into law. It may tell you it's with committee, this is at second reading, but the vellum copy doesn't come out, and there's this confusion of calling bills that have been passed bills instead of acts. The 25th of February 2022, Proceeds of Crime Recovery and Management Act 2022. It's a very controversial, I hope my UFCC friends are here. Money Laundering Prevention and Prohibition Act, another very controversial one. Terrorism Prevention and Prohibition Act, 12th of May. These three were passed into law on the 12th of May. The National Health Insurance Authority Act, the Business Facilitation Miscellaneous Provisions Act 2023, the Electricity Act, the Student Loans Access to Higher Education Act 2023. Now, it's not all these legislations that have the capacity to send one to prison, but for as regulatory lawyers, you may need to know in a summary what they contain. One is something that I think you should read out. The act, that is the Petroleum Industry Act, prescribes payment of fines as penalty for non-payment of hydrocarbon tax in section 292. A few other apparent penal provisions exist in the act, but strikingly, these provisions fail to stipulate the punishment for contravention of the law. Now, if you read backwards, you would see shall be punishable by a term of imprisonment or a fine to be set out in a regulation. To a fine to be set out in regulation. I now said, query. What about the provision? Can this anomaly, I consider it an anomaly, be challenged for breaching the provisions of section 3612 of the Constitution of the Federal Republic of Nigeria 1999 as amended, which provide thus, and I'll read it and I hope you get see the catch in it. Subject as otherwise provided by this Constitution, a person shall not be convicted of a criminal offense unless that offense is defined and the penalty therefore is prescribed in a written law. And in this subsection, this is where the catch, please listen. A written law refers to an act of the National Assembly or a law of a state, any subsidiary legislation or instrument under the provision of the law. So granted, you can be punished under a subsidiary legislation. But when the legislation is telling you that the punishment should be that provided in a subsidiary legislation, which, because of the new nature of the act, such subsidiary legislation has not been put in place. And the reason why they're doing this is this. Oh, today, dollar to, or then dollar to naira was maybe 1 to 385. Today is 1,000 and probably 20. So the man in charge of drafting the regulation will be summoned. Say, look, go and increase that regulation. These people now have the money to pay. The boss pipe or something. So increase it from 5 million naira fine to 50 million. Naira don't scatter. Now, the truth is, will that not be ex post facto legislation? Was that punishment in place at the time when the Petroleum Industry Act came up? So it is difficult to say it will abide, the punishment will abide what is. Supposing the regulation was made or prepared, or is made or prepared after the man committed the offense, which is very likely, the defense of State Council will be regulation is regulation. Is there any regulation? That's the punishment you will apply. But the Electoral Act, if you buy the book, we reviewed it therein, and is there. There's only one area that I would like us to consider. My very good friend Femi Falana has been in the news for going to court with 34 associates of his to challenge the influx into INEC of people who are known to be partisan. Nothing wrong with that. But like it is said, the politicians are at times several steps ahead of us. There are other offenses prescribed in the sections of the Act. Section 8.5 criminalizes misrepresentation, non-disclosure of membership, affiliation, or connection to any political party by staff or other officers in order to secure appointment with the Commission in any capacity. However, this provision does not expressly preclude officers of the Commission from being partisan. It merely requires them to disclose the nature and extent of their partisanship, because the punishment is for misrepresentation or non-disclosure, not for being partisan. There are two scenarios here. Will this provision not run afoul of the intendment of the Constitution, which says that an INEC commissioner should not be affiliated or linked to any political party? The Constitution itself is not self-executory, it's not executing itself. Which we refer to those ones, the Adamawa issue, and so there will be something for you in your spare time to read. Then the Proceeds of Crime Recovery and Management Act. All that I'm going to say on it is that it is one-sided. It is just loaded in favor of the recovering agent. I wouldn't have circulated this paper, it would have brought up an interesting debate. But I have refrained from going through it because Thursday, is it Thursday? Is the day that there is a whole session on confiscation of properties, and the Proceeds of Crime Act will be discussed. So I don't want to stray into the field of those who are going to do justice to it. By the grace of God, I'm also coming to come and tap from their specialized wealth of knowledge on Prevention and Prohibition Act. A very serious legislation. Of all the legislations, there appears to me to be the only balanced one. Might be because of the terror that everybody feels from the activities of. So it's not one man's problem. Both the poor, the rich can be visited by the terror of these people. Then the National Health Insurance Authority Act, Business Facilitation Miscellaneous Provisions, and the Electricity Act, Student Loans Access to Higher Education Act. All I've just done is to point out to penal provisions. In those, it will be very boring we've taken the interesting parts. In conclusion, this is an overview of the judicial and legislative updates and developments in Nigeria between 2022 and 2023. It is hoped that the authorities concerned will react positively to the comments and recommendations for improvements made where it is considered appropriate and relevant to the objectives of our criminal justice system. I thank you very much.
Please let us give the coordinator a resounding round of applause. You agree with me that those of us that have had the benefit of even looking at that paper, applause. Sir, you have, since there's no other resource person, you can take 15 minutes.
Thank you. My Lord, and the chairman of this noble Rule of Law Development Foundation, I adopt all other existing protocols. I will start by commending the master and the masterpiece delivery that we just heard. And then I want to say that all of you here will not envy my position as I am, in that the best has already exhausted the topics. Notwithstanding, however, we'll drop or chip in some few things that caught my attention personally with the Money Laundering Prevention and Prohibition Act 2022. And I will humbly refer us to Section 2 of that Act. That Section 2 is the section that gave the limit of the cash individuals can have and corporate bodies also can have, 5 million and 10 million respectively. Please let us take notice of that, of the Section 2 of that Act, so that we'll save ourselves from any imminent embarrassment. Having said so, I will also wish to comment on the issue of investigation, the lack of investigation of our authorities. The authorities, no doubt, have no provision. There's no provision, so to say, for comprehensive investigation. I would have suggested, if possible or if feasible, that the system, if you want to improve, really, if you really want to improve on our criminal jurisprudence, we need to have a department separate for investigation. That is, they should be built, they should be equipped with materials needed purely for investigation during prosecution. You can't get it right any longer. So therefore, to have a separate department devoted for investigation would not be a bad idea to shove up criminal jurisprudence. If we look at this case of Igwe, for instance, versus State, is one of the cases cited in the manual before us. That case talked about the front loading of evidence, witnesses, evidence, and all that. And then we have variations of should the defendant and his counsel be served ahead, or should the prosecution be free to just come up with anything during trial when you have not been favored with a plea that those documents are in existence somewhere. Because sometimes, most of these documents are not known to the defendant. The prosecutor is privileged to have all these documents, and the defendant don't know. So if you are now saying the defendant should be the one to ask for what he does not know exists, then I think his justice is both for the prosecutor, for the defendant, and for the state. Everybody should be equally treated and have this opportunity. The judiciary have tried, because we must admit that they find themselves in judiciary find itself in a difficult situation. A difficult situation in the sense that they are being hounded left, right, and center. I on the judiciary. This person on this is somehow not too palatable. I have appeared before a judge before in a criminal matter, an EFCC case. You will see that the judge is afraid of EFCC. Several afraid of EFCC. I don't want their trouble. Justice cannot be like that. Otherwise, innocent people will suffer. Now, a judex, a judicial officer, that can be called and be threatened that if you release this person, if you grant bail to this person, then we will deal with you. We have seen that severally. And if that is the case, and then the judiciary now have to throw up their hands in despair and say, okay, since I don't want trouble, I don't want to be embarrassed, whatever they want, I do. And then thereby sacrificing innocent people to suffer unduly. That will not be justice anymore. We read the quotation here that it's better for 99 criminals to go scot-free than to have an innocent person suffer unduly. Because of that, I give commendation to the judiciary. In the case of Federal Republic of Nigeria and Justice Nganjiwa, I could see an epitome of Lord Denning in Supreme Court in that decision, in that case, where they applied judicial activism to say that before any of our judges will be taken for criminal prosecution, we, the NJC, must all have a say. See, we agree that, strictly speaking, if you want to look at Section 308 of the Constitution of the Federal Republic of Nigeria, we know that judicial officers were not mentioned among those to enjoy immunity. We agree. But because of the sensitive nature of their job, whereby they will always step on toes. Abi? Judiciary will always step on toes now, because if two people come before them, they cannot give judgment to A and at the same time give it to B. So they must step on somebody's toe. And once they step on toes, many of our people are vindictive. and then they begin to hunt them. If they are not protected, innocent people will suffer. So kudos to judiciary, in my view, for this FRN case and the Ganjiwa in 2022, when Supreme Court said no, before you try any of our officers, any of our judicial officers, and arraign them for any criminal matter, NJC must give go ahead. Bring the matter to NJC, let us look at it. We agree that NJC does not entertain criminal matters, yes? But let it come under misconduct. Let us look at it. And if you now find that this person deserves to be prosecuted, we release. After all, the soldiers, they do it for themselves. Isn't it? What made them to be better than our judicial, our judex? So, and we are the last hope of common men. If we allow and open our judex to this danger, it will not augur well for anybody, because it is a mefele today. It can be you or me tomorrow. So a wrong to one is a wrong to all. We need to be attentive and be vigilant, especially those of us in this profession. I will say this, I think my 15 minutes is rounding off. I will also illustrate this contribution with one more issue, which is this case of discretion of the judiciary. Discretion of the judiciary. We all know that when we are talking of bail in judiciary, we know is purely discretionary. And then we also know that discretion is also guided. It must be exercised judicially and judiciously. Now, if you look at this case of recent case of Peter Nwaboshi against Federal Republic of Nigeria, in that case, the man was convicted at the lower court. He did not go to serve the sentence. He brought an application for bail and so on and so forth. And the case now had to be considered, this issue of bail. The court, looking at the whole circumstances, said, the man was sentenced to 7 years imprisonment. And everybody will agree with me that if the man should go to jail, if he's inside the correctional service gallows, and from there is fighting for his bail, from High Court to Court of Appeal to Supreme Court, 7 years will pass. 7 years will pass. That's the truth. 7 years will pass. And if at the end of the day, he now succeeds in his appeal, what happens? It becomes a case of live and for God. Because you can't redress it again. So therefore, my view is we need to embolden. I still commend the Supreme Court for this case of FRN and Ngajinwa. We need to embolden our judges to be more courageous, to be able to be the last man standing for the poor masses. When somebody was sentenced to 7 years imprisonment, and you said, and the person applied for bail, and then you denied the bail, and the matter runs through the 7 years, the bail, the man has served the sentence, and then the court now say, oh, he's innocent, he's free. What happens? Do you take away the sentence he has served from his body? You cannot. How do you even compensate that person monetarily? It's not possible again. So, in such a situation, the length of the terms of imprisonment should be considered in granting the bail. After all, it's not a capital offense. The circumstances of the matter itself, the nature of the allegation should also be countenanced, and the bail in such instance should be liberal. Should be liberal. What we should just do is to ensure that we have good sureties for the person. Have good sureties for the person and let the person enjoy his freedom. Fundamental human rights is a right given by the God Almighty. Right to freedom and all those things. It is eternal. It shouldn't be taken away lightly from any human being. And if that is done to one person, it's an injury done to all. And that should be discouraged as much as possible. Finally, sir, on this issue of forfeiture, Section 29 of EFCC Act, and so on and so forth. Yes, we know that the issue of forfeiture is going to be discussed later. But this power that the court gave to EFCC, especially on the issue of seizure, the court, that act gave them two powers. There is this power of seizure. There is this power of forfeiture. In fact, they also have the power to freeze multiple, plenty. And the issue of seizure, the act so much pampered, or should I say over pampered EFCC to the extent that they can do it ex parte. In fact, they don't even need any court order. When they want to seize, they just call, I handle a case, they just call the client. Yes, we traced this kind of money. The person bought a property from my client. He has taken over the property, is living there for more than a year. EFCC called, oh, we traced the money that it was paid into your account. It was a dirty money. So, oh yeah, bring it to us. If you don't bring it, we are coming to seal up your company. The man had to give them. And then the saddest part of it is this. After he released the money to them, and now went to meet the person, oh yeah, give me my key. You go to EFCC to go and explain yourself. The person said, I have no business with EFCC. You go and sort yourself out. As I speak, this is the 4th year the person is still in my client's house. We went to EFCC to complain that, CEO, they said we should go. They have collected their money. So, what made that to happen is because of the liberal power of seizure, which was given in the circumstance. If it was a motion or notice, we were served, we were invited to come and complain, to come and say our own version. We will not allow them to go with the money, and we will not allow this person to seize our property, and we are in the limbo. We are not getting our money, we are not getting our property. That cannot be justice to anybody. And it is still on as we speak. We now have to go and file a case and start. We are on our own. It is the problem, the genesis, the foundation of that problem is because of that power to seize somebody's property without any court order. I think that should be discouraged in our jurisprudence. When injustice to one is injustice to all. Thank you for listening. That is all that I have to say in contribution. Thank you.
Please, let's give Leonard Silk a round of applause. And as stated earlier on, we have almost come to the end of this session. As is our practice at the Rule of Law Development Foundation, the session is very interactive. And I will be calling on the chairman first to give his closing remarks. After the closing remarks, then we may take one or two questions or answers, questions or contributions from the audience, and then we'll end by 4 o'clock.
Thank you very much. We have been treated to a very stimulating discussion on the topic judicial update and legislative development, multiplicity of criminal laws, and harmonization debate. The first discussant, Mr. JB DAUDU, informed us that the aspiration and target of every society is to rid a society of criminal elements and their effects and its effects. And those crimes include acts of fraud, corruption, murder, kidnapping, banditry, terrorism, cybercrime, cultism, crimes arising from electoral misconduct, and so on. He said the propensity of investigation is characterized by torture, threats, force, intimidation, and promise of temporal advantages, which he said is not good. He further said the rights of people are not put in the correct positions. That Nigerians should take cue from the modern developments of modern technology and artificial intelligence, and that mentality of what I can get in my job should cease, and that there must be change of attitude. He talked about non-facility, such as crime laboratories. Courts and legislators must take advantage of the modern gadgets. He also said that the criminal templates must set mark for prosecution and investigation. Mr. Kanu Agabi, who first presented his paper, said that more laws breed more crimes, and that we are governed by dictators. He said we make more laws and more institutions for the prosecution of crimes. When I was growing up, there was only one prosecutorial body, that's the Nigerian police. The what do you call them? The fire service were under the police. The inland waterway police, the inland waterway is under the police. The fire brigade is under the police. And today, what do you have? You have set a lot of proliferation of departments separate from the police, and this has brought a lot of conflicts in prosecution and other things. If you go to some advanced countries, for instance, let me take Saudi Arabia. If you go to Saudi Arabia, all the enforcement agencies, you see them in one uniform. The only difference is the badge. That this one is a policeman, this man is a firefighter, this man is a soldier. They are trained in one institution. They undergo training in one institution. So they are equipped, and each of them have been trained for this comradeship, cooperation. But this is not what you find in Nigeria. In Nigeria today, the fire brigade has been something different. The road safety are there, and so on. there's this competition. Everybody wants to prove that he's on his own, and this is not good for this country. Something has to be done. Everybody wants to wear a badge. The fire brigade, the what they call them, Amateku, we wear their own badge. The Hizbah, we wear their own badge, and so on. This is not good at all. This is not good at all. So something has to be done. But Mr. Kanagabi said law enforcement agents work under harsh conditions without training, education, and kitting. You find that a policeman has no good shoes to wear. Their uniforms are tattered. In fact, the policemen in Nigeria buy their uniform. Even whistle they blow, they buy it themselves. For where do they get the money? Their salary is so poor. So that is an invitation to corruption. We should look into that also. And he said the same thing happens to the judiciary also. The judiciary is not well taken care of. And that government is source of crimes in Nigeria. That most of the crimes, their source is in the government. Take, for example, people are not well paid. And if they have opportunity to steal, they will steal. At least to make their ends meet. So government should do something about the welfare of its citizens, welfare of its workers. They should be well paid, well taken care of. When we are growing up, we go to hospitals, we are giving medicine free of charge. We go to secondary school, we are giving uniform, beds, 3 square meal, pocket money, and even transport money. But these are not the case today. People graduate from university, they have no job. And what they're going to do, if they have opportunity to making money, either legal or illegal, they will do. Kanagabi also further said that the good people in Nigeria are not being employed, are not given the right jobs. That substandard people are being employed. When there are jobs, instead of taking the best, you don't take the best. You take you take somebody who is your relative or relation, and this is not good. This is not good. That something has to be done about it. Mr. JB Daudu has discussed certain topics also. He talked about on the issue of legislative update. He said there's the need an overview of all legislations within the last 5 years, so that we know what those legislations are. And he also said that there are only three criminal legislations within that period of under review. On the recovery of process of crime, he said it negates the provisions of fundamental right and right to own property. On the terrorism provisions, no. He said that penal legislations, no. That is the issue of legislations with regards to this, what do you call it, electricity laws and other social legislation that the panel provisions of those legislations are subject to certain subsidiary legislations which are yet to be promulgated, and it calls on the authority to comply with the suggestions that we are making at this seminar. This discussant also talked about a separate department for investigation and he talked about exercise of discretion, and that judges should be more courageous, and the length of punishment should be considered in granting bail. Well, so far so good. this is what I'm able to produce. Let us thank the discussants, as well as those presenters of these papers today. We thank them very much. And on your behalf, let us give them a round of applause. Louder, louder, louder. Thank you very much. The chairman of this, the coordinating chairman of this symposium or this debate. I thank you very much for inviting me. In fact, I ought to be in Maiduguri today. In fact, I was to leave at 4 o'clock. I have a program that I'm chairing in Maiduguri. But because of the importance of this seminar, I have been a prosecutor. I have been a DPP in the Ministry of Justice. I've been chairman of a lot of criminal tribunals in the country. So these topics are of great interest to me. That's why I have to skip my assignment in Maiduguri to attend this seminar. I thank you very much for inviting me, and I really appreciate it. And I've learned a lot from it. Thank you very much.
I'm grateful. Let's give my Lord a round of applause. We have come to the end of this session, and I don't know if I have the permission for any questions or answers. If there are any interventions or questions, I don't know how many we have. Okay, the council we are here for a week. Okay, it's noted. I think the day is fast spent. We have other topics. Please keep your interventions. We're still here for the whole week. So please note, most of the topics are interrelated. So we can go ahead with that tomorrow. So we apologize for not taking the interaction because we spilled on from the opening ceremony. So I want to remind us that tomorrow we'll be here by 9 o'clock dot. 9 o'clock dot. And we'll be going into the aspect of criminal procedure. That is for our experts. We are going to aspects of criminal procedure, and we are starting straight at 9 o'clock. And our lead presenter tomorrow will be E.C. Ukala, Senior Advocate of Nigeria. And the second presenter will be Rotimi Jacob, Senior Advocate of Nigeria. And we have other eminent panelists to discuss that. Then we'll also be talking about the future of the administration of justice in FCT. And we have Justice Adeni there, Professor Akinsheye George. We also have DCP Simon Love SAN. We have the DPP, Federal Ministry of Justice, and a host of others who will be coming to do justice to these two topics. So please let us endeavor to be here at 9 so that we can start on time. So on behalf of the foundation, I urge us to please always enter our name in the attendance book so that you'll be able to get your certificates at the end of the day. And for those of us who are interested in these books, please see us after the 2 books that were presented to the public today. Please see us after the program for me to make it available to you. The prices have been advertised. The DAUDU's miscellany, which is this one, is 50,000 naira. It is 50,000 naira. That is the price of DAUDU's miscellany. And then if you are interested in the directions, which is this one, volume 5 of the directions of the LPDC, this is 30,000 naira. So please feel free to see myself or Chinelu if you are interested in copies of these books that have been presented. So on the whole, it is just my responsibility to thank all our distinguished and invited resource persons, guests, learned justices of the Court of Appeal, and all the senior advocates, branch chairmen, elders of the bar, and the journalists who have been here, and members of the bar. Thank you very much. It has been an action-packed day. Please join us again tomorrow as we continue with the full week of lectures. God bless you all.